Hi, my name is Ahmad Torakhel, as most of y'all probably already know. And yet again, you guys will probably see I'm not in class right now. I'm actually recovering from a bad case of bronchitis. But yeah, let's get this show on the road. At the mini presentation, or the mini case brief I decided to bring forward to you guys was R.V. Lifshitz, a case that was handled in 1997. The decision level was the Supreme Court of Canada. The case goes through to say that there is an individual, unlike most criminal cases, that brings forth the value of misinterpretation. The Canadian legal system and traditional legislature contains a lot of legal terms, specific with definition, and have little or no room for contest. It was intrigued to find an individual appealing with the legal language as a defensive mechanism to fight off his criminal charges. Let's see how that worked for him. Previously held in the Manitoba Court of Appeal in 2016, the accused, a stockbroker, was charged with one count of fraud and one count of theft, both over $1,000. It was alleged that the accused defrauded his employer with a large sum of money by misrepresenting the value of bond in his personal Canadian margin account. The accused was tried before the judge and jury. He was convicted of the fraud charge, but acquitted for theft. The accused's main grounds of appeal was that the trial judge erred in instructing the jury on the meaning of expression, proof beyond reasonable doubt. I'll say it again, the term proof beyond reasonable doubt. The Court of Appeal allowed the appeal, set aside the conviction, and ordered a new trial. Visited again in the Supreme Court of Canada, William Lifshitz appealed on the basis that the judge did not properly explain the burden of proof to the jury. He said that beyond a reasonable doubt is a simple and everyday idea that everyone understands. They understand it as a plain language approach. The court processed with the following. The following issues were presented. Main issue at hand. How should a judge charge a jury on the meaning of beyond a reasonable doubt? And the underlying issues consisted of, if charged, how should the concept be explained to the jury? Did the charge in this case amount to a misdirection of the meaning of the reasonable doubt? If the charge in this case was insufficient, ought this court give effect to the curative provision set out in section 686(1) subsection B subsection 3 of the Criminal Code? Analysis of the case. The jury must be provided with an explanation to expression of reasonable doubt. This expression, which is composed of words commonly used in everyday speech, has a specific meaning in the legal context. The trial judge must explain to the jury that the standard proof beyond a reasonable doubt is inextricably intertwined with the presumption of innocence, and the basic premise is fundamental to all criminal trials, and that the burden of proof rests on prosecution throughout the trial and never shifts from the accused. The jury should be instructed that a reasonable doubt is not an imaginary or frivolous doubt, nor is it based on sympathy or prejudice. A reasonable doubt is a doubt based on reason and common sense, which must be logically derived from evidence or absence of evidence, while more is required than proof that the accused is probably guilty. A reasonable doubt does not involve proof to an absolute certainty. Such a proof is impossibly high. Certain references to the required standard of proof should be avoided. A reasonable doubt should not be described as an ordinary expression which has no special meaning in criminal law context, and jurors should be invited to apply the determination of guilt in a criminal trial the same standard of proof that they would apply in the decisions they are required to make in their everyday lives, or even in the most important of these decisions. Nor is it helpful to describe proof beyond a reasonable doubt simply as proof to a moral certainty. The onus resting upon the crown to prove the guilt accused beyond a reasonable doubt and inextricably linked to the presumption of innocence. The jurors clearly understand the meaning of the term is fundamental importance to our criminal system, ensuring that no innocent person is convicted. The Marshall, Moore, and Milgard cases serve as a constant reminder that our system, with all its protections for the accused, can still make tragic errors. A fair trial must be the goal of the criminal justice system. There cannot be a fair trial if jurors do not clearly understand the basics of fundamentally important concept of the standard of proof that the Crown must meet in order to obtain a conviction. The decision. Based on the issues presented, the grounds and the jury and the judge brought forth, the appeal is dismissed, and William was convicted for his charges of theft and fraud. The reasons for this dismissal of his appeal are as follows. Corey, who was writing for the majority of the jury, agrees that this was not the correct way to describe beyond a reasonable doubt to a jury. Because it was not simply the plain understanding of it, he gives a list of things including in a charge. The standard of proof beyond reasonable doubt is inextricably intertwined with the principle of fundamental to all criminal trials, the presumptions of innocence. The burden of proof rests on the prosecution throughout the trial and never shifts to the accused. A reasonable doubt is not a doubt based on sympathy or prejudice. Rather, it is based upon reason and common sense. It is logically connected to the evidence or absence of evidence. It does not involve proof to an absolute certainty. It is not proof beyond any doubt, nor is it imaginary or frivolous doubt. And more importantly, more is required than proof that is accused is probably guilt. Jury, which concludes that only the accused is probably guilty, must acquit, and a list of things not to include. Describing the term as ordinary expression, which has no special meaning in the criminal law context, inviting jurors to apply to the task before them in the same standard of proof that they apply to the important or even most important decision in their own lives. Equating proof beyond a reasonable doubt to proof to a moral certainty. Qualifying the word doubt with adjectives other than reasonable, such as serious, substantial, or haunting, which may mislead the jury, and instructing jurors that they may be convicted if they are sure that the accused is guilty. Before providing them with a proper definition as the meaning of the words beyond a reasonable doubt. Corey provides a suggested charge at para 39, which has subsequently been adopted by all trial jurors. The accused enters a proceeding pursued by the innocent. That presumptions of innocence remains throughout the case until such time as the Crown has only the evidence put forth to be satisfied you beyond reasonable doubt that the accused is guilty. What does the expression beyond reasonable doubt mean? The term beyond reasonable doubt has been used for a very long time and is part of our history and tradition of justice. It is so ingrained in our criminal law that some think it needs no explanation, yet something must be said regarding its meaning. A reasonable doubt is not imaginary or frivolous doubt. It must not be based upon sympathy or prejudice. Rather, it is based on reason and common sense. It is logically derived from the evidence or absence of evidence. Even if you believe the accused is probably guilty or likely guilty, that is not sufficient. In those circumstances, you must give the benefit of doubt to the accused and acquit because the Crown has failed to satisfy you of the guilt of the accused beyond reasonable doubt. On the other hand, if you remember that it is virtually impossible to prove anything to an absolute certainty, that the Crown is not required to do so, such a standard of proof is impossibly high. In short, based upon the evidence before the court, you are sure that the accused committed the offense, you should convict, since this demonstrates that you are satisfied of his guilt beyond reasonable doubt. He says, other than the part in question, the trial judge's charge to the jury was clear. However, the part in question was enough to mislead the jury. The Crown tries to argue that Section 686B, subsection 3, applies. However, this is rejected as the court says that you cannot say the jury would have come to the same conclusion with the correct instruction. The ratio behind the case. The ratio behind the case is that when defining important criminal terms such as beyond a reasonable doubt, the judge must not simply use plain language definition. They must include descriptions of important underlying concepts to be proven to be acceptable. Laws implemented to misinterpretation would fall under section 686 that implies on the hearing of an appeal against a conviction or against a verdict that the appellant is unfit to stand trial or not criminally responsible on the count of mental disorder, the Court of Appeal in specific section B determined that the case of appeal may be dismissed if section 686B subsection 3 mentions notwithstanding that the court is on the opinion that any ground mentioned in subparagraph A, subsection 2, the appeal might be decided in favor of the appellant. It is of the opinion of no substantial wrong or miscarriage of justice has occurred. Finding that the plaintiff has denied the appellant was not in account or any mental disorder, neither was the court substantially wrong, displaying wrongful message through the eyes of justice. Cases like these bring great attention to even when an absolute wrong and undoubted crimes are held up against you, laws are set out with specific powers that have little to no room of bargain. And that for any upcoming lawyer, whether you're defending or accusing, pay attention to the correct terminology as it will save you a lot of hassle, and the cases like these could avoid any unsuitable reasoning for another appeal. In relation to critical theory, the law is necessarily intertwined with social issues, particularly stating that the law has inherent social biases. Cases like R.V. Lifshitz, even when dealing with relatable crimes, modern law is set for crucial debates, appointed through biases of cause and moral reasoning decided by judge and jury. Even if Lifshitz lost the case, he appealed under disagreement. Disagreement that terms like unreasonable doubt are held at high bias and will remain arguable in court. Hence, critical theory. Till next time.